Welcome back. Today we're diving deep into something pretty fundamental in criminal law, the Voluntary Act. I mean, if you didn't consciously choose to do something, can you actually be guilty of a crime?
That's the core question, isn't it?
Yeah, so we're looking at the defense of automatism, basically legal unconsciousness. Think about it. Someone commits what looks like a serious crime assault, maybe worse, but claims they were totally blacked out.
Right.
So the big mission for us today is figuring out the legal standard. Specifically, who has to prove what? Who carries that heavy legal burden of proof when someone claims they were unconscious?
And that burden question is, well, it's a bit of a legal landmine. It sounds simple, but it gets complicated fast. People often mix up unconsciousness with insanity. But legally, they're worlds apart. If you successfully argue automatism, you walk free, completely absolved. Why? Because there was no voluntary act.
And crucially, no commitment to a mental hospital, unlike an insanity finding.
Exactly. That's why getting the classification right is so critical for the courts and obviously for the defendant.
Yeah. Okay, so how are we going to tackle this?
Right. So, to get you up to speed, we'll first define automatism, nail down what specific conditions might count.
Okay.
Then, critically, we'll draw that clear line between automatism and insanity. And the main event, really, will be a deep dive into a landmark case, State v. Cadell. That case really shook things up regarding the burden of proof.
Sounds like a plan. Let's start with the basics then. Criminal Law 101 says every crime needs a voluntary act. So if automatism negates that, how exactly do the courts define it?
Okay, so legally speaking, automatism is when a person engages in conduct that looks criminal, but they're actually in a state of unconsciousness or maybe semi-consciousness.
So they're moving, acting, but not aware.
Precisely. As legal scholars like Lefebvre and Scott point out,
Right.
the action lacks the necessary volition. It's not an act in the eyes of the law because the person wasn't conscious of doing it. Therefore, no criminal responsibility.
We hear about this defense. Courts are, well, pretty strict about what qualifies. Why draw the line so tightly? Why do things like sleepwalking or a concussion count, but say just forgetting afterwards amnesia or being blackout drunk doesn't?
That comes down to why the person was unconscious. The defense requires an involuntary loss of consciousness.
Ah, okay. Involuntary.
Yeah. So the conditions courts generally recognize sleepwalking, which is somnambulism, hypnotism, a serious concussion, diabetic shock, maybe an epileptic seizure. These are usually seen as involuntary interruptions of conscious control.
Right.
Amnesia doesn't count because you were conscious when the act happened. You just can't remember it now. And voluntary drunkenness. Well, as Lewis v. State established, that's generally seen as self-induced. You chose to drink, so the resulting unconsciousness is considered your own fault, legally speaking.
Okay, that distinction, involuntary versus voluntary, sets up the next big point. Why treat automatism completely separately from an insanity defense? On the surface, both seem to negate the required mental state for a crime, right?
They do seem similar, but they're distinct in both their cause and their consequences. The absolute key difference is whether the condition results from a disease or defect of the mind.
A disease of the mind, okay.
If the automatism is, say, temporary and purely physical, like from that concussion we mentioned, it's generally not considered a mental disease. And here's the crucial consequence. Because it's not legally insanity, a defendant found not guilty due to automatism isn't subject to that mandatory commitment to a hospital.
Which is huge. Freedom versus potentially years in an institution.
Exactly. And that's why you see defense lawyers fight really hard to frame conditions like epilepsy or sleepwalking as pure automatism, even though some courts have occasionally hinted they might be, like unto insanity.
Okay, so that difference, freedom versus institutionalization, brings us right to the heart of the controversy. The burden of proof. Who has to convince the jury?
Precisely. This is where courts really split. Does the prosecution have to prove the defendant was conscious beyond a reasonable doubt? The argument there is that consciousness is part of the voluntary act, which is an element of the crime the state must prove.
Makes sense.
Or does the defendant have to prove they were unconscious, treating it as an affirmative defense like insanity, where the defendant raises the issue and has to prove it?
So which way does the law lean? This conflict really boiled over in a North Carolina case from 1975, didn't it?
It did. Let's analyze State v. Cadell. First, what are the legally dispositive facts?
Okay, the key facts. The defendant, Willis Tony Cadell, was charged with kidnapping and assaulting a 14-year-old girl, Catherine Sutton. Her testimony was harrowing. She said he forced her into his car, drove her into the woods, beat her, tried to assault her sexually.
A brutal scenario.
Absolutely. But Cadell pleaded not guilty. His story. He testified he remembered driving his car, hitting an embankment before any of this supposedly happened, and then nothing. Complete blackout until later. His defense was automatism, likely from a concussion from that car incident.
Okay, so a classic automatism claim based on potential head trauma.
Right. And what was the core legal issue the appeal court had to decide?
The central issue was about the jury instructions. Did the trial judge mess up by giving instructions on the burden of proof or unconsciousness that seemed contradictory? There was confusion because of an older binding case in that state.
Conflicting precedent always causes problems. So what rule did the Cadell court ultimately apply?
This is where the major shift happened. The court majority declared that unconsciousness or automatism is a complete affirmative defense. It's separate from insanity, yes, but it's an affirmative defense.
That's affirmative defense, meaning the defendant has to prove it.
Yes. And crucially, in doing so, the court explicitly overruled its previous decision on this exact point, a case called State v. Mercer. For lawyers in North Carolina at the time, this was huge.
Wow. Overruling precedent.
Big time. The new rule from Cadell is that the burden is on the defendant to establish the defense of unconsciousness to the satisfaction of the jury. Unless, of course, the evidence supporting the defense comes out during the state's own presentation of its case.
Okay, overruling Mercer is a big step. What was the court's analysis? How did they justify putting that burden squarely on the defendant?
Well, the court's reasoning drew parallels. They essentially said, look, unconsciousness functions a lot like the defenses of insanity or intoxication. In all these situations, the defendant is basically saying, yes, I physically did the act the state described, but I didn't have the necessary mental state.
A kind of confession and avoidance argument.
Exactly. And since the law already presumes people are sane, the court didn't see a strong reason to treat temporary unconsciousness, whether from a concussion or diabetic shock or whatever, any differently. They applied a similar presumption. You're presumed conscious unless you prove otherwise. And they also added a sort of a policy reason. They explicitly noted that courts often distrust a defendant's simple claim of having blacked out, especially if there's no other evidence.
Wait, really? They basically admitted they distrust the defendant's word on this and use that distrust partly to justify shifting the legal burden.
They did acknowledge that skepticism. It suggests they felt shifting the burden was necessary partly to prevent defendants from easily faking a blackout defense.
But doesn't that create a risk? What about someone who is genuinely unconscious but maybe can't afford fancy medical experts to back them up?
That's the potential downside, absolutely. It's a policy tightrope. The majority seem to prioritize consistency with the insanity defense rules and perhaps guarding against fabricated claims, potentially at the risk of making it harder for a genuinely unconscious person without resources.
Okay, so that was their reasoning. And the final conclusion in Cadell's specific case.
They upheld his conviction. They found that even though the trial judge's instructions were technically flawed because the judge was still referencing the old, now overruled Mercer standard, which was confusing, that error actually worked in Cadell's favor.
How so?
Because the flawed instruction suggested Cadell might not have any burden, which was better for him than the new Cadell rule requiring him to prove unconsciousness. Since the error helped him, it wasn't grounds for a new trial under the correct standard they just established.
Got it. So the conviction stood. Let's really test the impact of this Cadell rule. Imagine a defendant, maybe never diagnosed with diabetes before, they're driving, suddenly go into severe diabetic shock, completely involuntary, no warning, and cause a serious hit-and-run accident while totally unaware. Under Cadell's majority rule, does that unlucky person now have to prove they were in diabetic shock to the jury's satisfaction?
Yes, absolutely. Under the Cadell approach, where automatism is an affirmative defense, the burden falls squarely on the defense team to convince the jury about that diabetic shock. They have to establish that temporary, non-fault mental lapse.
Even with no prior history, no fault.
Even then, and that really highlights the contrast with the other view, the minority view, which you see in cases like People v. Hardy. That view says, no, the prosecution always has the burden to prove consciousness beyond a reasonable doubt because a voluntary act is fundamental, maybe even constitutionally required.
A stark difference in who has to do the convincing. Now, the Cal majority put the burden on the defendant, but there was a strong dissent, wasn't there? Led by Chief Justice Sharp, she argued unconsciousness should never be an affirmative defense. What was her core argument? She used an analogy, right?
She did, and it's a powerful one. Chief Justice Sharp argued that unconsciousness isn't really an excuse like insanity. Instead, it fundamentally negates an essential element of the crime itself, namely the voluntary act. Without a voluntary act, the crime, legally speaking, didn't happen as charged.
Okay, so it's not avoiding blame. It's saying the core requirement wasn't met.
Exactly. So she argued it should be treated like an alibi. If you claim an alibi, you're saying, I wasn't there. You don't have to prove you weren't there. The state still has to prove beyond a reasonable doubt that you were there.
Or like claiming a death was an accident.
Right. Like a plea of accidental homicide. The defendant doesn't have to prove it was an accident. The state has to prove it wasn't an accident, that it was intentional or reckless homicide. Sharp's point was, voluntary action and unconsciousness cannot coexist. Therefore, the burden must always stay with the state to prove the act was voluntary.
That makes a lot of sense logically. The dissent also pointed out a practical problem with treating automatism like insanity based on how defendants actually plead these defenses. What was that?
Yeah, this was a really sharp observation. Insanity is often, as we said, a confession and avoidance plea. Okay, I did the physical actions, but I wasn't mentally responsible.
Right.
But Sharp argued that someone who was genuinely unconscious, like someone who had a concussion or a blackout like Cadell claimed, often couldn't possibly know for sure if they actually committed the act the state alleges. They were unconscious.
So they can't really confess to the act.
Exactly. They'd likely just deny doing it because they have no memory of it. Cadell himself denied it. If you can't honestly confess to the act, how can you fit it into that standard confession and avoidance model of an affirmative defense? It just doesn't fit the reality of the situation, according to the dissent.
Okay, we've unpacked the definitions, the crucial distinction from insanity, and this major split, the Cadell majority versus the dissent on who carries the burden of proof. This has been a lot to digest, so let's synthesize this. For you, the listener, facing an exam question or trying to analyze a real-world scenario involving a blackout claim, what's the actionable step-by-step checklist?
Okay, absolutely. If you run into a situation where someone claims they acted unconsciously, here's a 4-step framework to diagnose the issue and apply the right rule. Step 1. Is this really a voluntary act issue? First, confirm the claim is true automatism acting without conscious awareness. Immediately distinguish this from things that don't count, like just forgetting afterwards, amnesia, or being unconscious from voluntary drinking or drug use.
Got it. Filter out the non-starters.
Step 2. Is the source a disease of the mind? This is critical. Was the unconsciousness caused by something temporary and not considered a mental disease like a concussion, maybe carbon monoxide poisoning, diabetic shock? If yes, it's automatism, not insanity.
And that dictates whether commitment is on the table.
Precisely. That's your major fork in the road regarding consequences. Step 3. Analyze the burden of proof. Now, you need to know the rule in your jurisdiction. This is the Cadell split. Is it the majority? Cadell rule. If so, treat automatism as an affirmative defense. The defendant has the burden to prove unconsciousness, usually to the jury's satisfaction.
Okay.
Or is it the minority? Dissent pre-Cadell rule. Here, you treat it as negating the state's case. The state keeps the burden of proving the act was voluntary, meaning the defendant was conscious beyond a reasonable doubt.
So you have to know which rule applies where the case is happening.
Absolutely essential. Finally, step 4, check for corroboration. Remember the practical reality we discussed from Cadell? Courts are often skeptical of a defendant just saying, I blacked out.
Right, the skepticism factor.
So, look closely. Does the defense have anything beyond the defendant's own word? Is there medical evidence? Eyewitnesses who saw the person collapse or act strangely? A documented history of epilepsy or diabetes? Lack of corroboration significantly weakens the practical chance of the defense succeeding, regardless of the formal burden of proof.
Well, that's a super clear framework. So what we've really seen is that how the law defines conscious action completely changes the outcome. Criminal conviction versus potential freedom, maybe treatment. And that core legal fight over the burden of proof, affirmative defense versus negating the state's case, that determines who has to convince the jury of the defendant's awareness or lack thereof.
It really does. And it leads to maybe a final provocative thought for you to consider. The whole system kind of rests on this presumption. Men are presumed to be conscious when they act as if they were conscious. It sounds reasonable, right?
On the surface, yes.
But think about it. If we follow the Cadell rule and put the burden on the defendant, what happens to that person who has a totally unexpected first-time medical event? Maybe the first seizure they've ever had. They act erratically, maybe cause harm, but they genuinely weren't conscious. If they don't have the money or resources to get sophisticated medical testimony to prove their unconsciousness against that strong legal presumption, well, are we ensuring due process? Or are we potentially punishing someone for being medically unlucky rather than criminally culpable? That's a tough balance between public safety and individual justice that the courts are still wrestling with.